Good afternoon, everyone. Can you do full screen for the presentation? Put it in PowerPoint mode. Thank you. Okay. So yes, my topic is, as you have it on the screen, rethinking traditional knowledge protection in the intellectual property arena, the use of trademarks and geographical indications. I would like to start by thanking Strathmore University Law School for inviting me here. And of course, the people in the kitchen, Professor Juan and Marianne, for making it possible for me to physically come in and make my presentation. I feel like Strathmore Law School is like a home to me. It's my third visit here, and I always enjoy it when I come to a beautiful campus. As you've heard from the introduction, I do love intellectual property, both the practice side of it and the academic side. And of course, there's so many synergies in what I'm presenting today with the thematic position that we have, because my presentation is premised on customary law, cultural heritage, which is also about the spirit of Ubuntu, oneness, and that connection with culture is there. And we're looking at how that interconnects or relates with intellectual property, which on the other part is individualism. And then when we turn to talking about natural law, from what you've heard with the previous speakers, the concept of customary law in itself has something to do with natural law as well, although some other schools of thought also apply, like the sociological school of thought and the like. My topic is bringing out issues related to two sides. One, how communities think in terms of how they experience, enjoy, and appreciate their culture through their traditional knowledge, and how intellectual property thinkers have borrowed ideas from such communities, and then, of course, individualize this knowledge for commercial benefit. Things my clicker doesn't work, so you'll help me from the other end to shift the slides. I will be talking about defining, of course, the key terms. For many of us who do not understand the key terms, I will start off with talking about this. Then I'll bring in the challenges protecting traditional knowledge through the intellectual property regime. I'll talk about the similarities, the underlying similarities between intellectual property and specifically traditional knowledge. And then, of course, going to case studies. Where has this played out very well? Where have we seen traditional knowledge successfully protected through the IP regime, through specifically trademarks and geographical indications? And where has this not gone so well in the sense of the bad side of it? And then, of course, the ugly side, where you don't even have any appreciation of where this knowledge comes from. And of course, I'll conclude and try and discuss a few ways forward. So starting with the defining of the key terms, of course, what is intellectual property? We're talking about intellectual property, and the simplest way to look at it is anything that comes out of creativity of the mind, anything that puts money into thinking and you innovate or create is your intellectual property. And when you gain that intellectual property, you want to protect it. If it's an innovation, you give it patent protection. If it's a design, you've come up with a design, you give it industrial design protection. If it is literary or artistic works or performances, these are expressions. So the way that you've expressed it and put that expression into some fixed form, you get copyright protection. If it's plant varieties, that's one of the new areas of intellectual property where you are combining different plants and you bring out some unique characteristics that show that the plants have a distinctiveness, that they have a uniformity in the way that they grow in, and as well as stability, then you get plant variety protection. If it has, and we'll be talking about GIs in more specific nature, if you're looking at goods or services that have a unique character to them that is tied to their place of origin, you get geographical indication protection. If it is a secret in which you have some profit that come out of something that you do that is really unique to yourself, and you keep it secret, you go through reasonable efforts to keep it secret, then you get trade secret protection for it. In some places, they call it confidential information, the way it's protected. And then, of course, we have names, signs, symbols, colors, smells, gestures that are connected to particular services or goods get trademark protection. So those are all the types of intellectual property rights that come out of any creativity of the mind. Moving on, we want to also try and understand what traditional knowledge means. If you have a community that has a particular skill and this skill is tied to the cultural heritage of that community, and they have a way in which they use that skill to come up with particular goods or services, then that is traditional knowledge. This may be coming out of the environmental way that they're attached to their skills. It may come out of their medicinal knowledge. In as long as you have some intellectual activism within a community, the Ubuntuism from a particular community, and it may be intangible, that it's not seen, it's a bit of knowledge that they use in their intellect. Or it can be, the outcome is tangible, as we'll be looking from the different examples. The knowledge systems around that is what we call traditional knowledge. So it's basically a reflection of one's social and cultural heritage or identity that is characterized by their know-how, their skills, their innovations and practices that are specific to particular indigenous persons or communities. And then moving on from that, we also need to understand what we mean by, can you move on to the next slide? What we mean by trademarks. And I've given a few examples here of a bunch of trademarks from South Africa. So signs that distinguish one organization's products or services from those of another. Probably Tom is the best person in this room to identify each of those trademark examples because they're all from South African companies. So if you look at a particular mark and it reminds you of a place that offers those services or offers those goods, then that's what we call a trademark. The duration of protection is normally 10 years and it's renewed indefinitely every 10 years that it's expiring. And we'll come back to that duration when we start looking at the synergies between trademarks or geographical indications and traditional knowledge, because we're looking at longevity in terms of protection. The other unique thing about trademark is that they are normally, in most instances, protected as certification or collective marks. And we'll look at what that means as well. The next, we look at geographical indications. What do geographical indications mean? With geographical indications, we're looking at any products or services that are connected to a place of origin. And that origin brings out a unique character or characteristic in those products or services. So I've given two examples there. You have Parma meat, which is like pork, from a region called Parma in Italy. It has a unique taste. It has a distinguishing nature to it that you will not find in any other place. So because it comes from a place called Parma in Italy, it's known as Parma meat. The other is Tuscan wine, Chiantis wine, sorry, which is also coming from a place in Italy. So these are also unique to specific places that are made by people within those places that understand how these work. And the duration for protecting geographical indications is also 10 years, renewed indefinitely every 10 years. They can also be protected as collective marks or certification marks. So moving on, what do we mean by collective or certification marks? It's called a certification mark if it is someone or a group of people who have provided the means through which this product or service is being done. So if it comes out in a way that it meets particular prescribed standards, it is certified as fulfilling the qualities that the people look out for. On the other hand, it is a collective mark if a group, a body, or an association get together and they collectively come up with these goods or services, then they give it a collective mark. So this is unique in the sense that the collective or certification mark is within the realm of intellectual property rights protection, as we've seen with GIs and trademarks. But we also see the same with traditional knowledge, that communities come together and create things of this nature. So what challenges then would fall within trying to place intellectual property as the best way to protect traditional knowledge. First of all, traditional knowledge protection, as I've said, is attached to communities. It has been there for time immemorial, whereas intellectual property is normally attached to individuals. You'd know these individuals, you know where they come from, and because it is picked from a particular time, then you can count the duration or how long you're going to protect the IP for an individual. But you cannot attach a time of protection for traditional knowledge because you don't even know when it started. So it's like fixing a square peg in a round hole. You can't pick a duration, you cannot identify the person that created the traditional knowledge. And then when you go into boundaries, it's easy to appreciate the limitations and expectations and exceptions in intellectual property protection, that you'd be able to say that if it's for experimental use, for instance, you can be able to use an innovation without being accused of patent infringement. But the same limitations and exceptions do not exist or apply under traditional knowledge, where, on the other hand, would be seeing communities having to give prior informed consent before their knowledge is used. So the focus of interest is another challenge with intellectual property. Of course, the focus is profit, it's commerce. And that's not the priority in most instances with traditional knowledge, where the focus is preserving cultural heritage. So then can we say that IP is the best way to protect traditional knowledge? Well, maybe, but not necessarily. With geographical indications and TK, there are certain similarities still that come in. The first is that you're looking at one product or one service, but many producers. It's a whole community. We see this both under traditional knowledge. We also see it under geographical indications, that you have various people coming up with one similar product. And then with geographical indications, they do actually get to use traditional formula in creating the products that they come up with, some of the products at least that they come up with, all the processes. The examples that I pointed out of the Parma meat or the Tuscany wine are about processes that have been used, that are using traditional knowledge to create them. The know-how in both GIs as well as traditional knowledge is transmitted from one generation to another. It exists for time immemorial. We probably all know that a generation lasts 30 years. So from one 30-year group to the next, this is knowledge that is easily transmitted, both in the perspectives of geographical indications as well as in traditional knowledge situations. The products also have a close-knit relationship with the land or the local resources or the environment in both settings of geographical indications as well as TK. We also see that you actually have a long period of time. As I've said, a 30-year period of a generation is quite long to start linking a product to a locality. And this happens both in GI settings as well as TK or traditional knowledge settings. And because of that, the value of the product, the commercial value in both instances is always tied to the place where the product comes from. So yes, there are similarities worth appreciating. So having seen the challenges as well as the similarities, we still are faced with situations where we have to question ourselves whether IP, specifically trademark or GI protection, is the best way to go for traditional knowledge. So we start by looking at the good cases, good case studies. What do they tell us? So starting on, there's a place in Ecuador, Professor Juan would probably know this place, where they have green leaves from the tequila plant. Please go ahead and show those green leaves. So they harvest those green leaves, and then the next bit shows the strenuous process they go through, drying them, and you can see from the slide, the man is going through quite a lot using traditional knowledge skills to come up with the last bit there that you have. I don't know why they call it a Panama hat when it's not coming from Panama. It's actually coming from Ecuador. But that's the Monte Cristi hat that is made out of a traditional knowledge process. But has it been protected through traditional knowledge? Not necessarily. The community felt that the best way to go about this would be through geographical indication protection. So when we move on, we see that in 2005, quite a group of Takwila artisans filed an application for a GI, geographical indication protection here. They argued that the only community members from the place, which is Monte Cristi, and surrounding regions should be the ones allowed to use the label. They were looking at quality and ensuring that it only comes from them. In 2008, the straw hat, Monte Cristi straw hat, was officially recognized as an appellation of origin from Ecuador. So GI protection was hereby given. So now you see it's sold in various places. Second example is the Khoichan, different blankets. They use them for hats, mittens, and the like. You have the Khoichan tribe, which is a community in British Columbia in Canada, that have been producing these different products for literally hundreds of years. So they too felt that they could not simply sit back and rely on their traditional knowledge means of protecting the Khoichan sweaters and all those other mittens. So they did file and got a certification mark, after which they got intellectual property protection for their product. Third example, which is also the good, we see right here in Kenya, region of Taita Taveta County. People there are really good at making baskets. We have some people from the Taita here. Yes, there is someone here. So probably you also know how to make those baskets. So they decided that, yes, we have this traditional knowledge. Let's protect it using intellectual property. They registered Taita basket trademark to identify with their traditional knowledge. So those are some of the good examples we have. The bad, you've probably heard of the Chikoi battle that happened back in between 2008 and 2012. Chikoi is a form of cultural expression, I would say maybe folklore, that comes from mainly Kenya and Tanzania. You also have it in Uganda, but of course it's mainly Kenya. So within the period between 2008 and 2012, a person in Britain was trying to register a trademark for Chikoi. Government of Kenya put in an opposition in the UK to stop this from happening. At the time, they relied on the old Copyright Act before the amendment of 2019, the 2019 amendment in Kenya, which allowed for the government to authorize and prescribe terms and conditions governing any specified use of folklore except by a national public entity for non-commercial purposes or the importation of any work made abroad which embodies folklore. So they relied on this and were successful in stopping the trademarking of Chikoi, because this would have meant that you cannot export the Chikoi out of Kenya. You cannot utilize this as traditional knowledge or folklore because you'd have to go through the person that owns the trademark. So that was a bad case, which ended up at least as a good way forward. Then from my home place, my home country, Uganda, we have a community. The biggest community in Uganda is called the Baganda people. And they're also known for a 700-year-old tradition of making bark cloth. The picture on your right is an example of the bark cloth that is made. The picture on the left is the process they go through in making this bark cloth. So they strip bark off a tree, which is the ficus tree. In my local dialect, we call it the mutuba tree. Take it through a harvesting process, pounding and all, until the hardness becomes really soft and they produce the final product that you have there. So when you move on, what we're seeing in the next slide is a situation where a person called Oliver Haynes, that's the picture you have there. The next picture is his wife. She's Ugandan. So she, I would assume, is the one who gave the idea to her husband that, hey, there's this big traditional knowledge in Uganda called bark cloth. So they have been making various products through their company called Baktex. It's a German company called Baktex. And a few examples that you also see on the screen are products made out of bark cloth within Germany. Mainly in the motor vehicle industry, they've been supplying Mercedes-Benz Chrysler with parts made out of bark cloth. Recently, they entered into a big commercial deal with Puma, the shoe company in Germany, and Puma is now making sneakers out of bark cloth. So you have this individual or this company that is definitely making a lot of money out of traditional knowledge. Of course, they employ some farmers from Uganda to harvest the cloth. So probably about 400 farmers also make some money. But then the question is, how do you relate a community-owned tradition with a particular company that's benefiting commercially? So moving on, we also see other cases, which in this case I'll call the ugly. In Gabon, they've been utilizing a berry called the Ubli berry for quite a long time. It helps against various ailments, diabetes, and some non-communicable illnesses. So they use it as a traditional medicinal product to heal these ailments. Some years back, some researchers from the University of Wisconsin in the US were able to study how the women in Gabon were using the berry to treat themselves. And they went back to their labs, extracted the protein, and in isolating and extracting the protein, they discovered how things work. So they came up with an easier version of doing this, having borrowed the idea from the local community in Gabon. And when you see it from the next slide, you see that the University of Wisconsin were able to get a patent. They did mass production of this, and in their mass production, their products are much cheaper than the local community in Gabon were marketing theirs. So they practically rendered the people of Gabon, worthless in their products in using this berry. They kept on insisting that they had never gotten their idea out of Gabon. So that's a bad case, a really ugly case. The global market, of course, for that artificial and high-intensity sweeteners that were created by the University of Wisconsin is estimated to be worth $3 billion. So you can imagine how much of that would have benefited the local community in Gabon. So what is the underlying argument here? Can we look at the good cases, the good case studies, and insist that TKs can be protected as trademarks and geographical indications? Not necessarily, because it's not a one-size-fits-all. They're good cases. We have had some successful cases, but not everywhere. Some motivations are not about money, and therefore the communities don't look at that as what should prompt them. Then you have a problem of communities that are in different countries, same community split by boundaries. We have that between Kenya and Uganda. We have communities between Uganda and the Congo, or Uganda and Rwanda, that's same communities but different countries. So how will they protect their traditional knowledge if they're coming from different regions? Many indigenous communities also look at it as taboo to utilize their knowledge. It is sacred to them. So intellectual property wouldn't be the way to go for them. Next slide, please. So the conclusion would be that intellectual property, which focuses on enforcement of rights and profits, is different from traditional knowledge, which focuses on protecting and preserving culture. And you will always find conflicts because of that to say that trademarks and GIs are the best way to go for traditional knowledge. What has to be done is to balance these two perspectives, intellectual property on the one hand and GIs and trademarks on the other hand, and see what works and what doesn't work, where are things applicable or not. And because of that, we would advocate for what we call a sui generis or unique form of protection, unique in the sense that it is applied to the setting that is before it. Remembering that one size does not fit all. The principles of prior informed consent and access and benefit sharing for communities are very well applicable within a sui generis setting and would be hard to apply in an intellectual property setting. We see that Kenya has applied these within its Traditional Knowledge and Culture Protections Act of 2016. Zambia has done the same. South Africa has also done the same. And many other countries should do so as to fully enjoy the spirit of Ubuntu. Thank you.
Thank you very much, Dr. Anthony, for the interesting speech. I would like to ask the audience if they have any questions or inquiries.
Thank you for the wonderful presentation, and it's been quite interesting. But I'm just wondering, in regards of protecting traditional intellectual property, would it be okay if a community does not want to share the information? They don't want to go through the process of patenting it, but they don't want to commercialize it. It's not a groundbreaking discovery. So ideally they can't be forced to share it with the world. Would it be okay for them to be allowed to retain that information? Yeah, thank you.
Okay. So thank you very much for your question. There are certain communities, I've been doing these studies for quite a long time now, almost 10 years or so. And there's some communities I've discovered in my research that yes, they consider some of their cultural norms as really sacred to them, and they do not share them. And even within those communities, their families, for instance, what they call bond setters. There's specific families that are the ones involved in healing those who have broken hips or bones and the like, and they don't share this knowledge. And that is respected by all the others. So what is being advocated for at the bigger front through the World Intellectual Property Organization is for them to find a unique way in which they can apply this knowledge without revealing the core aspects of this knowledge. One example of that is the Traditional Knowledge Digital Library, TKDL, Traditional Knowledge Digital Library of India, where they have been able to share their knowledge with various IP databases across the globe without revealing the core aspects of that knowledge. So they keep the core to themselves, but are able to prevent others from getting to that core, and they just sell, for instance, they have the Indian TKDL has partnerships with the US Patent and Trademarks Office, as well as the European Union IP Office, where if people are applying for patents, they would consult with the Indian government, and the Indian government would tell them that there's prior art in this, you cannot grant a patent here because it's connected to our traditional knowledge. So they have not revealed everything about their traditional knowledge, but they still bring out aspects which show that there are those similarities. So the respect is given to them that this is their culture, this is their sacred norm, and they'll keep it secret, but we don't get into capturing all that knowledge away from them. I hope that answers you.
Thank you very much for your response. If there is no more inquiries, the next speaker for the day